Hi folks, you're with Tacitus today. Tacitus today at your Pushback channel, and thank you for joining this audio live stream. In this essay, I'd like to talk about the separation of powers. This is the separation of judicial power from, or judicial legal power from political power. I'd like to talk a little bit about how it came about and how it developed, why it developed, and maybe have a look at where it is today. Now, the idea of the separation of powers is in some countries it's more of a convention than an actual constitutional sort of law. It's more enshrined constitutionally in the United States than it is in, say, somewhere like Britain or Australia or Canada, for that matter. But the outcome is ostensibly, or meant to be at least ostensibly, the same. When the American British colonies declared independence, there was already quite a body of work in this idea of separation of powers. So they already had quite a strong basis to sort of go from, and in a position more to enshrine it in a constitutional document than, say, it was in Britain, where again it was not that there weren't laws around it, but it was tending more to convention and agreed convention than necessarily a group or body of laws. So let's just have a look at now. How did it come about? Well, the issue with the independence of the judiciary is something everybody wanted the judiciary to be independent if they were not in power. If they were in power, then they did not want an independent judiciary. They wanted to use the judiciary to go after political enemies, people they didn't like, people who'd offended them or slighted them, or people that they thought might have been a problem, or just folks they thought they could extract more taxes from, or whatever. So it was very much an idea whoever was in power could go after anyone they didn't like. Now, this was particularly an issue in places like Britain, where there'd been, say, minor civil wars, or where there'd been substantial disputation over lines of succession. So the king dies, and then there are half a dozen people saying that they have a claim to the throne through some sort of blood relationship or whatever. So when you get all these people running around, it's a kind of a civil war, and they would, wherever they had control, whether it's in the central government in London, again, but I'm using England as an example here, but whoever was in control would then use the legal system to go after their enemies, because then you've got access to control of the courts, control of the police, or the army units, and all sorts of things like that to just arrest someone. So you can go to the prosecutor and say, okay, I want Billy Bob arrested. Why? Oh, I don't fucking know. Make something up. I just don't like the dude. And then Billy Bob can be arrested and thrown into prison. So, but then the guy who's got control of London and the judiciary, there's one of the other claimants to the throne has raised an army, and they kick that dude out, and they get into London, and they want to use the judiciary to go after people they don't like, including arresting and hanging or executing the dude who was sitting in the seat 5 minutes previously. So there's there can be different people getting control of the mechanism, if you like, of the legal system, and then using it for very personal and vengeful reasons. So this turning and froing and changing and always being in doubt as to who's going to come after you and when and why, got people thinking about that the courts really should be independent. There's quite a lot of talk about it in the 1500s and or even before that, for that matter. Now, at the time, rather than common law, which is sort of really what we have today, or maybe more tort law in the United States, but instead of common law, there was really what was called canon law. It was really coming from the church, in effect, and the basic laws of God, the Ten Commandments, that sort of thing. And really, if you went into a court, you were being judged by God. That was the sort of if you like, the aura of justice that was being put forward in a court of law. So or a canon law court really at the time. So when we look at the arguments to and fro, the feeling was that if we have an independent judiciary, then people can all agree on the verdicts reached by the court and will accept them, rather than viewing the court as simply a device, a prosecutorial device of whoever was in charge at the time. And this, of course, is important, faith in the legal system and belief in independent justice. Now, that sort of ping-ponged around for really, well over 100 years, if not longer. And things like the Spanish Inquisition also created or fostered this view that courts should be independent of not only political influence, but even of undue fanatical, ideological, religious influences, as in the case of the Inquisition. So there were many arguments and many people who believed in this independence, or that this independence was needed, including things like the writs of habeas corpus, that you can't just arbitrarily arrest someone and while you try and dream up some sort of charge against them, and keeping them in prison this time while you try and work it all out. This was also the case where again, in civil war type situations, where somebody would temporarily grab control of the legal or judicial process and start arresting people. But given they'd in the interim lost control, they would just keep these people in prison until they got back in control and could dream up some charge against them. So there were many shortcomings in the way justice was administered. And this was something that needed to be addressed. Now, probably the thing that really nailed it was when the British Parliament or English Parliament voted to execute the king. This was following the English Civil War, and it was a parliament dominated by the Puritans and Oliver Cromwell. Now, they had some reasonable, they had some reasons, given the times and the situation. They had some reasons for wanting to do it. The king was considered to be very pro-Catholic, and and England was Protestant, and all the forces that were gathering to support this king were Catholic. So there was a feeling that not only would if the king was still alive, not only would he be a rallying point for these Catholic invasion armies, but it could quite possibly result in the Catholics taking control of England again and executing all the Protestants. So there was a whole lot of other issues going. But the decision to execute the king was really, and they cut his head off, for goodness sakes, was really ginned up by Cromwell and his Oliver Cromwell and his goons. And so when the king, when the Cromwells, that government of Oliver Cromwell and later his son sort of fell apart, and they brought the king's son back as the monarch, then this idea was that you separate the power of the judiciary from the well, in this case the monarch or even the parliament, and judiciary must decide cases separately based on the evidence and the facts and so on. So now no one can deny that's a better system, but when you have power, these people, they want to use a corrupt judiciary, and when they don't have power, they want I want the judiciary to be independent. It's a bit like the racism, the people who when there's a certain race of people who are not in power, they want, or not in the majority, they want equality and equity and anti-racism laws, but once they're in the majority, then they don't want those laws anymore. In fact, that's where we are in the West at the moment. In my view, as soon as these groups achieve majority dominance, which a lot of them are vying for that in the West now, their numerical dominance, they'll all these laws that exist for to protect against race and so on, they'll all be gone. They won't exist anymore when white people are the minority. So anyway, this separation of powers is key and critical, and to a functioning democracy. And at the time when it's being talked about, democracy only exists in a very limited sense, 2 or 3% of the population getting to vote and so on. But there was enough people in there, the lords, the district squires, other landholders, and even merchants in the mercantile age, that just didn't like this idea of arbitrary power. being, the judiciary or the legal system being used to prosecute people who the goons in charge didn't like. So there was always this groundswell of an independent and impartial judiciary, and that's how it came about and where it developed from. Now, because there were so many competing interests of power, the independence of the judiciary was, following probably the early 1800s, I guess, was never really fully challenged. It waxed and waned and went back and forth, and habeas corpus was abused at times and not. But today we're in a different situation where the rule of law, due legal process, and independent judiciary directly contradicts and threatens the globalist project. And therefore, there has never been an effort to compromise the independence of the legal system that we're seeing today. And it's rampant all across the Western world. And this is something that should be of great concern to all of us. Anyone who's concerned about, habeas corpus. I mean, look at the people being detained from the January 6th drama. Some of these people have been in prison for 2 years without trial. And the writ of habeas corpus might as well not exist as far as they're concerned. This is political prisoner arbitrary arrest, arbitrary detention, and we should all of us, every one of us, be absolutely outraged by this. If you've got something to nail these people, you bring them to trial and you bring that evidence into an independent court of law. That's how it's meant to work. If you haven't got that, let them the fuck go. You can't detain people just in a functioning democracy with the rule of law. You can't detain people like that unless you have criminal evidence of criminal behaviour and you bring that evidence into a court when it's tested in an independent court of law with an impartial jurist or judicial officer. So we're seeing the independence of the judiciary and thus the separation of powers being compromised than never before. I just want you to think back to when President Donald Trump was appointing constitutional judges who would determine the validity of a law based on the Constitution, was appointing constitutional judges, and the absolute furor about that. The pro-globalists we want globalist judges in there that will judge it on the basis of its suitability to implementing and furthering the globalist project. That one thing, those 3 judges appointed by President Trump, constitutional judges appointed by President Trump, that is the only thing, that's standing between complete globalist supremacy and what we have now, where the globalists are simply preeminent but not totally in control. So we need to treat separation of powers as being absolutely critical. And again, it's being lost. Folks are being dragged into court on the basis of they've got views the globalist cabal doesn't like. The police are being used as globalist enforcers and so on. And this should worry everyone, regardless of what you think about global. It doesn't matter what you think about mass migration or trans or LGBT and so on. The rule of law and due legal process and attendant to that, the habeas corpus, must never be tampered with, because in the end, all of us will be devalued and all of us will be threatened by its loss. You've been with Tacitus today, your Pushback channel. Thank you for listening.